It's Thursday morning, 9:30 in Switzerland. It's Space Café time. Our Space Café Law Breakfast with Steven Freeland will begin soon. Thanks for joining us for our breakfast roundtable today. You see this wonderful coffee house environment. We come together. So more about that later from Setsuko. As always, we appreciate your participation and your ongoing feedback. I'm Torsten Kriening, your co-host today and publisher of SpaceWatch.Global. We are a Switzerland-based online platform for information in and about space and new space activities in a geopolitical context. I know many of you are already familiar with our website because we are all a big family here, our bi-weekly and daily newsletters and the Space Café podcast. Maybe also you have seen our new Space Café radio and of course our Space Café web talk series. We also keep our fan shop open online for you, where you can support us actively and become a Space Watcher. The edition 1 has cool items for you, your friends and the ones you love. Your support is needed to keep our work alive, and we do that for you. If you've missed any of our previous web talks, we have an archive available on our website in the event section and on YouTube. We will host our Space Café Law Breakfast with Steven Freeland, as you know, live on a bi-monthly base. And with that, I'm over almost, and I'm handing over to your host today, still in lockdown in Sydney, Professor Steven Freeland. Steven, the floor is yours.
Thank you, Torsten. Thank you so much. Hi, everybody. Yes, still in lockdown. I think we are now in week 15, I think, in lockdown and still counting. And I was saying to our dear friends on the panel, the beauty of wearing headphones is it keeps your hair down, because otherwise my hair would be all over the place. Welcome again. Thank you so much for joining us. There's so many webinars on at the time, so we're always so delighted when people take the time to come and join us for our Space Café, Space Law Breakfast. This is the 5th in the series. We're learning as we go. It's fun. We get great people along. We try to demystify what's going on in space. We try to talk about not just the narrow confines, but the what, why, how, and when of space. But there's so much going on at the moment, and we really are so lucky to have two amazing guests, dear friends of mine, and they're incredible people and incredible thought leaders, Dr. Setsuko Aoki and Peter Hulsrodge. I'll formally introduce them in a minute, and I'm delighted that they're with us. But of course, as Torsten mentioned, here we are. We're having breakfast in this wonderful cafe in Tokyo today. So Setsuko, perhaps good morning to you. Well, theoretically, good morning to you. I know what time it is for you and I, really. But tell us where we are here in sunny Tokyo.
Yes. Thank you, Stephen. Well, this is a cafe near my university, Keio University, and Tokyo Tower. And Keio University, the oldest university in Japan, is almost also next to Australian embassy and the Italian embassy. And areas near to the embassies usually have refined cafe and restaurants. Here are no exceptions. We can take good pastries, cakes, and of course, good coffee. And in addition to that, we can order some Japanese cakes made by rice and beans. I'm enjoying today's coffee. And well, I hope this would be shown. This is daifuku, typical Japanese cake, well, rice cake. And literal translation is daifuku means big happiness. So, well, with this daifuku, well, I'd like to enjoy with you. Thank you.
Oh, thank you, Setsuko. Big happiness. So we have daifuku. Peter, I understand you've got a typical Danish breakfast pastry. Is that right?
That is right. I'm very impressed that Tokyo Cafe is serving also a unique Danish breakfast roll. I don't know if it's sure. Yeah, there you have it. You'll see what a fantastic pattern This is the Danish response to the croissant. It's, of course, much, much better. And the name frøsnapper means frog grabber or something like that. But this is, of course, another of these cute Danish words. So perhaps we cannot compete with the Japanese in terms of existential message of our food, but we can be cute.
Yeah, I've heard the Danish language described in many ways, but cute is not one word I've ever heard. So it's nice to hear. Torsten, what have you? That's right, frøsnapper and rullgrøn med fløde, I remember. Torsten, what have you got?
Oh, today I decided to stay at home and just prepare a sandwich here, or as we would call it here, or as we call it here in Berlin, eine Stulle. So, Stulle. Yeah.
Stulle, thank you.
Not as cute as frøsnapper, for sure.
And I have a bagel here from Iggy's Bread, which is the best bread shop in Australia. But to go with my bagel, I have these you can't really see, these wonderful cookies. It's terrible, isn't it? Made by our dear friend Annie Hanmer, who's the host of SpaceWatch.Global Australia, and Annie's in the audience. They are the best cookies in Australia. So there we are.
We should sell her cookies on our shop.
Online, that's right. Yeah.
Thank you for not sharing.
So let's delve into the wonders of space law with Setsuko and Peter. So much has happened, as I say, and this is an exciting time for space. For example, it was pointed out to me just yesterday that last week humanity set a new record for the most number of people in Earth orbit. Last week we had at one point, we had 14 people in Earth orbit. 7 on the ISS, 4 aboard the Inspiration 4 Dragon, and 3 Chinese taikonauts. So exciting, but it also highlights, I think, the need to understand even more governance, regulation, and indeed the theme of today's talk of today's breakfast is what is space law? You know, we'll be looking at some fairly fundamental questions about the most appropriate way to approach global governance through international law, asking questions about does that singularity of approach really capture the true nature of what's going on in space? How is the law being developed? Where is the law being developed? What's the relationship between national law and international space law? So we've got a lot to talk about. Let me now formally introduce Peter and Setsuko. As I said, they're dear friends, they're amazing colleagues. First, we've got Dr. Setsuko Aoki, who's a professor of international law from Keio University. She specializes in international space law, arms control, and export control, has her Doctor of Civil Law, DCL, from McGill University. She's the Vice President of the International Institute of Space Law. She's a member of the Committee of the National Space Policy in the Cabinet Office of Japan and a chair of that committee's Security Subcommittee. She's also the chair of Legal Subcommittee at UN COPOS. And Setsuko, I have to say, you were just superb in the way you ran Legal Subcommittee earlier this year in unusual and difficult circumstances. Setsuko writes prolifically on space, and 2 recent English publications included an article in volume 44 of the Journal of Space Law on nationality for spacecraft revisited. And in the proceedings of the International Institute of Space Law, she's recently written an article, International Cooperation Mechanisms in Outer Space for the Next Decade. So very much a forward-looking writer as well. Setsuko, welcome. Peter Hulsrodge, who I've known for a long time as well, currently working as a legal consultant for intergovernmental organizations. He was a director of the European Space Policy Institute and formerly a director of legal affairs and external relations at the European Space Agency. He's been a practicing attorney. the head of procurement and legal affairs at UMETSAT, and a legal advisor to the CTBTO. He's written, again, numerous articles on space law, on international law. He's the author of 2 books with a 3rd one about to come out, The Optional Society, coming out in November. Peter, I hope everybody will buy it. And Peter also has a blog, which is fascinating. The blog is www.whatifwedon'tdie.com. Very philosophical and deep, I must say. Peter, welcome. Thank you both for being with us. Before we get started on the questions, we've got to, of course, answer the question that's on everybody's lips. We ask all of our guests to describe in one word how they would see space and space law. And just to remind you, we've had Chris Newman, who's in the audience today. G'day, Chris, who thought space law was expansive, and Donna Lawler, who's also in the audience, talked about it being extraterrestrial. Tanya Masson-Swan said it was infinite. PJ Blount, innovative. Jenny Tapio, cooperative. Alex Suchek talked about its reassuring nature. Alina Morozova, who's in the audience, talked about its changing nature, and my dear friend Andre Mishtal, who's also here with us, talked about it, how ordered it was. I've described space and space law as intergenerational, and my co-host Torsten talks about it in terms of being ambiguous. So there's a range there. Setsuko, yes. How would you describe, what's your word for space and space law, and why do you choose it?
Well, instantly it comes to me, the humankind. And the reason is in the interpretation of established rules of international space law, I tend to find some leap from the strict legal interpretation of the existing law for the sake of the benefit of the humankind. The subject of international space law is, well, it's state, but the word state is used, but reality, the subject of international space law, hidden one, is humankind, and which emerges, especially in a critical moment. So humankind is my word.
Oh, thank you, Setsuko. And yes, we must always remember the humanity that space represents. So I think that's a wonderful word. Okay, Peter, over to you. What's your word to describe space law?
Thanks. Setsuko's word again, I cannot compete with such a wonderful perspective. But I wanted to preface this by saying that I think you are violating the human rights of lawyers by asking them to choose one word, because lawyers cannot choose one word or one solution. We know that. So you're putting me on the spot. My word is indispensable, but I was in doubt whether it shouldn't be fading instead. So I will use indispensable to explain why I think fading might also be relevant. I think it is very important that we remember that in outer space, which is a relatively new domain, that we need order, as somebody said. This was a word of somebody else.
Andre mentioned it, yeah.
And order is ensured by law. So law is indispensable. And we have been very privileged by having space law being defined very early on. This is very unusual for law because normally there is a very significant lag between when events take place and law catches up. But in our situation, it was upstream, and that was very good. And it was so upstream that perhaps we tend to take it a little bit for too granted, and perhaps we go about space law in too cavalier fashion. So we need absolutely, in a domain for humanity, we need to have the rule of law. And what I've detected over the last period is that rule of law And that's not only in space law. I think I have to say it's generally in international relations. That rule of law is starting to erode a bit. So I think one can also say that space law right now is fading. And you will hear from my comments that I'm not a great fan of that. We will discuss more about this later on. But we should be conscious of the great treasure that we have in the rule of law in space and the rules we have, which does not mean that we shouldn't look at them critically, but we should understand what the constraints of rule of law are, and we should respect those because this is ultimately in everybody's interest.
Great, thanks, Peter. So yeah, look, I think everybody would agree with you about the indispensable nature of law and the rule of law. And of course, it's dismaying to hear about your perception of law, the law fading. And you know, as lawyers, as humanists, using Setsuko's words, we all have to ensure that, you know, order, as you say, and the rule of law is maintained. Thank you both. Let's move on. Obviously, the cafe centers around law, but what we try to do is demonstrate the multifaceted nature of space. And we all recognize that as well as being considered in legal terms, we've got to think of space in strategic terms, in civil terms, in humanistic terms, commercial, scientific, cultural, religious, geopolitical, military. There are so many facets to space. And yet, it's true to say that sometimes think outer space is a means, an end into itself. It's something apart, and that therefore space law should be something apart that sits on its own. There's a reluctance amongst some, perhaps, to incorporate or to turn to other areas, environmental law, disarmament law, even international criminal law, in the discourse about space. So, Peter, can you help us sort of unpick this seemingly binary approach to the way the rule of law operates in space, and how best can we aim to have a more holistic view to governance in space? Peter.
Yeah, I think you are onto something very important. So it is true that in our environment, we are all excited about space. And there's nothing wrong in that. Some people see it as the daring do and so on. I'm not one of those. I'm very fascinated by space science and what it tells us about the human condition and the world around us. I'm excited about Earth observation and how we can use that for good stewardship of the Earth. So it is true that we have to be careful to understand that space is also a servant of other human endeavors and objectives. And going with that, as you are alluding to, is of course that we cannot look at space law in isolation. One has to say that in primitive legal systems, it is true that there is this tendency to believe that they are self-standing, that you can find any answer within those constraints, within the constraints of that legal system. And I think 50 years ago, you could perhaps argue that this was also true for space law. If you had 50 years ago a question related to space, you would almost always find the answer just in the space law treaties and the ITU, I have to say, because ITU is, as you have discussed earlier in the cafe, an essential part of the space law complex as well. But this has changed. This has changed very dramatically. With globalization, we also globalize issues, and with the intense use of space and intended use of space, many more disciplines become relevant. And one prominent one is, of course, environmental law. So environmental law is is fundamental for a fragile environment like outer space. And we already in 1992 in the Rio Declaration had statements about how states had to make sure that they took the environment into consideration in their activities, even if they transcended the national jurisdictions and so on. And this is something which we must absolutely heed. So environmental law is an essential part of this, and we cannot understand space without understanding environmental law. We have disarmament law, so we know that disarmament treaties are monitored to some extent by space-based means. So we need to look at that. We need to look at the law regulating weapons of mass destruction. We need to look, of course, at telecommunications. We need to look at international criminal law. So stovepiping is absolutely dangerous here. And it has, apart from us potentially getting to the wrong responses for specific questions, also the risk that we tend to see the issue as being, does space law apply? And if it doesn't apply, then another system takes over completely. And that clearly is not right. And this is something which is very relevant right now, because people tend to say, if there will be war in space, only international humanitarian law, so the laws of war, will govern. This is, of course, wrong. The laws of war will have an essential role, but will have a role which is defined by space law. So people are saying, but the nuclear weapons judgment of the ICJ says that only international humanitarian law will govern. This is not what the judgment is saying. The judgment is wrong and is sloppily formulated, but it clearly says that if shooting in space, or if shooting starts, then it is not only international humanitarian law, it is international humanitarian law in a much broader context of law. So it is never a binary thing. And stovepiping is, of course, making everything binary. We have to look at it in the variety of contexts that our rich legal fabric provides, and only then do we get the right answers.
Yeah, I think that's really interesting. And Setsuko, though, you could look at it the other way around, of course. As you know, of course, we have Article 3 in the Outer Space Treaty, and that says specifies a requirement that space activities are to be carried on in accordance with the international law. And some people have said, well, all international law can be applied in every way to space. So is Article 3 the answer to the dilemma that Peter raised? Peter says, we've got to stop being too narrow in how we look. Should we regard all international law as applicable, or does that then lead to anomalies given the unique nature of space? So how far do we take Article 3 and yet avoid the singularity of approach, the too narrow approach that Peter worries about? Setsuko, what do you think?
Thank you for your question. Well, I'll assess my assessment later. So at first, I think in an abstract way, all international law is applicable to space activities grounded especially in the UN space treaties. But I'm afraid that this assessment may not be as effective as we could hope because of especially two reasons. First, rules in the different fields of international law could collide very often. One example would be the free trade provisions in the WTO GATT that could be compromised for the protection of the environment, which is often discussed in the WTO panel. Concrete answers and solutions have to be found each time to solve conflicts of rules. Both are established in international law. In case of the collision of space law and IHL, it's not a question if space law is special law to the IHL and applies predominantly or vice versa. Each time, reasonable answers should be found, noting a specific situation, background, and circumstances, with the possible assistance by even other fields of international law. A tailor-made solution should be created, being helped by the experiences of other fields of law. And the second reason is, if not a conflict of two rules, there may be the cases rules could be too ambiguous to directly apply to concrete situation. Interpretation is not necessarily strong enough to convince all parties, and making new rules in the field of space law is eventually needed. So the importance of Article 3, so my assessment starts here, seems to me that this is a clear statement that no state may venture into action that is against the rules and the principles of the existing international law. And the most important existing rules is no use of force. Thank you. This is my answer.
Thank you, Setsuko. And I really like the way you take Article 3 and you show the nuance of it. So, as I said, a lot of people say, aha, everything applies, and then they cherry pick what they want to get their solution. But what you're saying is, yes, we've got to look beyond just the narrow confines of space. But really what Article 3 is saying, you don't do things that clearly are against international law. And I think that's a really good way of putting it. And thank you also for emphasizing the prohibition on the use of force. I just want to ask you, Setsuko, one other thing, just on that same issue. Peter mentioned the ITU, and we had Elena Morozova, wonderful expert on our last panel, who talked about the importance of the ITU for satellite operators. And yet some space people seem to think of the ITU, if you like, as a poor cousin, not really relevant to what we do when we look at the treaties. So you're the chair of legal subcommittee. You are so involved in COPOS. How should we rethink the primarily intergovernmental nature of COPOS to bring in other inputs from non-governmental entities and from other agencies? Are we too narrow in the way we consider the problems leading to governance structures? Whereas the ITU, for example, as we all know, has many industry players and others as part of the process and the discussions. And are we too narrow in COPOS, or how do we bring in those other voices? Setsuko.
Oh, yeah, it's very difficult. Well, ITU was originally the oldest international governmental organization, or when it was established, well, it was not realized as an international governmental organization. It's more as an international administrative union. And traditionally, the sovereignty of the ITU had been very strong, but yet now private actors are parties, while not full-fledged member. But ITU changed itself to accommodate itself to the time and for the prosperity of the business and for the betterment of the and well-being of the people in the world. So ITU is a success story. UN COPIOS, it's the main vehicle of the space lawmaking, has a lot to follow the ITU success story. But I think, well, this has a fundamental difficulty because it's a part of the UN, United Nations. It's not an well, independent organization or specialized agency. So realistically, the first step is to welcome private entities as permanent observers and also take inputs from the private actors, which would be facilitated inside events, technical presentations, and various workshops and seminars held under the auspices of the UN USA. So with United Nations at first, well, sovereign states would get used to private actors. That stage is needed. And then finally, these efforts would result in giving private entities associate membership of the UN COPIOS. Private participation is needed for the betterment of the world and peaceful uses of outer space. But cautious and gradual steps seem to be needed at this moment.
Yeah, thank you, Setsuko. I agree, and in the recent discussions that I was involved in, also with Legal Subcommittee and the plenary of COPOS, of course, the issue of how you balance the intergovernmental process with getting the inputs and the information from other sources, private entities, etc., who are perhaps involved more in the technology. It's still something that we're grappling with to try in the right way. So thank you for your clarification. So Peter, coming back to you, is the problem with... Sure, go ahead. Yeah.
But let me just apologize for leaving the cafe for a moment, but I saw that my computer was running out of power, and I thought it would be a little bit embarrassing if suddenly I disappeared, although some viewers might prefer that I disappeared, but I would still like to let my voice be heard. But let me just comment on what Setsuko was saying, because as always, Setsuko is right and is precise in how she puts it. But I think there is a fundamental issue behind this as well, which is that if you, like me, see space law as to some extent fading, one of the questions will be, how do you get people invested in space law and in the rule of law so that they understand what is at risk if they, instead of the rule of law, follow the rule of wishful thinking? And I think it is absolutely correct and in line with democracy ideas, etc., that you have to have all the stakeholders heard in some way or another. So I think, and I will not say that only about COPOS, but I think generally speaking, our community must be alert to the voices of the variety of stakeholders. And they are not only commercial actors, they are also, space scientists. There are many stakeholders in this. And if we want to build a solid governance system and so on, then we need to hear those voices. And we will not always like what those voices are saying, but they need to be heard. And it is clear that we build governance systems based on the state concept, because this was what was relevant 60 years ago. But the world has changed so much. So we need to understand that we cannot be state-centric in this. And again, of course, I like what Setsuko was saying about humanity. So we need to look at it from a much broader humanity perspective. But I'm sorry, Steven, I interrupted as always.
No, that's absolutely fine. And I think that it's a really good point to make, that the institutions that we have, and not only for space, but in so many other areas where you've now got issues of global concern, the institutions are still based on a state-centric process, as is international law generally, and is that appropriate? So let me go to you, Torsten. You speak to space lawyers all the time, right? And not only space lawyers, but let's focus on our own. And of course, they're leaders in their field. They're experts, but they are charged in a sense with directing the governance structures. But do you, without mentioning names, perhaps get a feeling sometimes that perhaps the lawyers have insufficient sort of cross-disciplinary knowledge? You know, they don't understand the science, they don't understand the economics, they don't understand the engineering, they don't understand the cultural aspects and the civil aspects and all the other aspects. Do you think, you know, the space lawyers, as hard as they try, need to do better and broaden their horizons in the way they think? You're speaking, of course, to 3 space lawyers here, so don't be too insulting, but it's important that we get your perspective. Torsten, what do you think?
Thank you, Stephen. And I mean, I try to fulfill my role here as the reality check. And what the 3/4 of an hour of discussion that we had already showed me is you're coming from this high level, pretty academic, pretty governmental speech or context to a certain topic. And of course, we talk here about highly complex environments. Nothing is easy. And you're right. I'm speaking to a number of space lawyers in the space cafes or in other formats. And what I recognize that many of them have their background in the real world, in the technical environment, in coming from commercial or an environment. So there are just a rare number of people that just space lawyers. Most of them are coming from a different background. Sorry, my picture was frozen. Somebody just called me. What is not nice usually.
You're fine now. You're fine now.
However, I mean, we see in the questions that we get from the audience that we really have this discourse going on. I would like to pick one question and throw it in here from Claire. Could you please give an example of these high-level principles on which states still have different points of views regarding space law? That's one example, and yeah, but we have others, but we are running out of time if we go through all of them. But I think this connecting to the real world environment is absolutely important, especially today. We have seen last week, as you mentioned earlier, the Inspiration 4, a great achievement. But it seems that commercial companies do what they want or what they can do in the legal framework, and we are letting them do wherever that will lead us. So there are these 2 tracks at the moment, in my opinion.
Yeah, that's interesting. Okay, so let's turn to that question that you raised from Claire. Thank you for the question. Examples of high-level principles on which states might have different perspectives or different interpretations. Setsuko, Peter, any thoughts on that? Setsuko, perhaps?
About definition and delimitation of outer space. Maybe it's one of the examples. You know, some states have a strong opinion that it's needed, and without it, the unstable situation of the loom and the rule of law would be deteriorating. And some others think it's not necessary, at least at this moment. And well, this is more, I think this is less based on the practice than belief or creed. Well, yeah. If I might say.
Yeah, it's such a fundamental issue, isn't it? And as I often say when I talk about it, it's not a legal question, really. I mean, it's a political issue. Mm-hmm. And so there's politics, you know, you've got countries saying we need it, some countries saying we don't need it. And they tend to be in these camps for political and other reasons. Peter, what about you? What's a principle that you think states don't really share in terms of a universal interpretation?
Well, Claire's question is obviously good, but perhaps I can broaden it a little bit and say that there are principles that states might not agree about. There are also principles that states should perhaps not agree upon. So I'm hijacking the discussion a little bit, perhaps, because there are two issues that are very prominent right now in our community. And one is space mining, and the other is space for military uses. And I have to say that one of the things that bothers me in terms of the democracy of space law, if you wish, this is a complex concept, is that we are seeing very dynamic actors, powerful actors in the space domain, who are saying we can do space mining. I know this is a sensitive topic for you, Steven,
No.
so I don't want to put you on the spot, but they are saying ultimately there are no legal constraints on space mining. There are powerful states saying war in space is inevitable, and the only thing that we need to respect is international humanitarian law and so on. There is no consideration of the province of humankind in this. What I'm surprised about is that there is so little pushback against this by the states that will ultimately suffer from this, if you wish. So if we take the militarization of space or military conflict in space, and the people who are saying that it is inevitable, and perhaps will make it inevitable by saying that it is inevitable, when you have those people, then I do not understand that all those who are unlikely to ever have any military conflict in space do not push back and say, but this is a province of humankind. You cannot ruin my global commons because you have a bilateral conflict with another country. So I don't understand that there is not a larger voice of states that are not onto the militarization of space perspective against what ultimately might become a reality that we cannot get away from. And the same on space mining. I have to say, you know, I'm a simple-minded person. I think we all know in our hearts of hearts that the Outer Space Treaty is outlawing mining in space for profit. But there is a very strong lobby right now saying, oh, but it has to, and we cannot leave the resources there, etc., etc. My response is always yes, and that was why we created the Moon Agreement. So if you want this, either you modify the Moon Agreement or you join the Moon Agreement, or you find some sort of alternative solution to this. But you cannot just override the rule of law. Again, I don't understand why states that are not themselves in this space mining mindset, why they do not push back and say, but you want to mine in a province of humankind without giving me any direct benefit. Without letting me be part of the governance of this. This cannot be right. And I think one of the things, and this is a question of, you know, legal dynamics in general, I cannot understand how people who have benefited from the regime that was established 60 years ago, why they are not stepping up and defending it. And the risk for all of us is, particularly with the militarization of space, that ultimately, within very few years, we can have made it useless for all of us. We will all be losers, including those who fought the original fight. But space is so fragile. You shoot up a few satellites and you make orbits useless for decades. We cannot allow that. We cannot allow this conflict is inevitable to take over common sense.
Yeah, and for me, a lot of it is the language of space as well. You know, we need to de-emphasize certain things perhaps, and maybe emphasize the common interests, as both you and the humanity that Setsuko talked about, the common interest in humanity of space. We need to emphasize that more in the dialogues. And, you know, I actually think that is happening slowly at the international level, and certainly with a push by civil society. But it brings to another point, and Setsuko, perhaps I could bring you in on this, about then the relationship between this international global governance, where, as I said, we push the common interests, although Peter says we've got to do that more, and then national interests. And, you know, national interests reflected also in national law. As an example, although I don't want to focus on the space resources in particular, but as you've explained to us in the past, some people say to me, the only space law that's happening is at the national level. It's only at national law. International law is not changing. I mean, I don't agree with that. I think there's a lot of multilateral processes going on. But in Japan, for example, they've recently passed a law, just recently, I think in June, about space resource activities. I don't really want to focus on mining unless you want to, but how does national law on an issue that the international system is also looking at, how does national law play a part, you know, given that it might or it might not, and I'm not saying the Japanese law does, but others might impact on the sort of broader discussions and maybe differ from the global views that are ultimately achieved. So how does that work that relationship between national law and international law?
Oh, thank you for your very difficult and interesting
question. I'm
sorry. So at first, I think for the function, there are at least three functions of national law relative to the international law, well, in the field of international space law. And the first is an lawmaking function by national law, and a dominant state or hegemon. Well, some state, at least three states are very dominant states at this moment in international space activities. Well, they tend to harness the power of spillover with national law to international society if corresponding rules are ambiguous or non-existent. So, well, for instance, in the case of space resources mining, I think, Article 2 of the Outer Space Treaty doesn't say anything about space resources mining. And Outer Space Treaty doesn't give any standard for economic development. That is given in the Moon Agreement, but not in the Outer Space Treaty. So, well, there is no, I think basically there is no law about space law mining in the Outer Space Treaty. So it's not, if it's not forbidden, state A may be able to resort to that action. But even if state A is free to do that, it doesn't mean that other countries shall accept it and respect all the conduct of state A as a legal obligation. So it's state A has just a justification of an action, but the consequence is unclear. Some reactions, maybe retorsion in international law, maybe conducted by state B or state C or more states. So national law in this case made by state A could be the first action to create concrete rules to induce reactions from other countries. And actions, reactions, and discussions would eventually lead to a new lawmaking. And if hegemon does act, that has advantages, but it's one of the, function of the lawmaking. And in case of the Japanese national space law, about space resources, that it's different. So, and I will tell it to you later. And second function of the national law is to ensure that its nationals could appropriately implement international space law. It's Article 6 of the Outer Space Treaty. In this case, national laws play a role of the realization of international law as an agency of international law. And the third is enrichment of international space law by multilateralism. And the Japanese Space Resources Act, I think, belongs to that. Usually, national space laws are made for multiple reasons. And in addition to the implementation of international law, a law is made to give governmental assistance to the nationals concerning a highly dangerous activity, such as launching a rocket, or to induce foreign customers and investment for space businesses, and for coordinating with other necessities to protect its nationals and territories, such as the environmental protection, human rights, intellectual property rights, and so on. Then, so Japanese space resources law belongs to that. I think because it says, it's so sorry. I'm taking too much time, and
no,
that law was just made last June, and Japan really didn't need it because Space Activities Act of Japan, made in 2016, duly give its nationals to get a license for space resources mining, because control of satellite is very widely defined in Space Activities Act. Control of satellite includes to operate spacecraft and robots to explore and exploit any space resources on the celestial bodies. So Space Resources Act was made to make detailed and tailored licensing regulations and supervision for a future operator of space resources exploitation, so that they shall act strictly pursuant to the updated international standards and international cooperation measures, not only international law. So it is true that ownership is admitted under the Japanese Space Resources Act, but this is not a unilateral act. That cannot be just be given. That has to be done in conformity with international space law. So this belongs to multilateralism, and it's different from the Hegemons Act to try to spill over its national law to create a new rule. And I don't think that itself is not a bad thing. If there is lacuna, it has to be done. Somebody has to do that. And then reactions are waited from other countries. Then new law would be created. Thank you. Sorry, it's a little bit too long.
No, it's wonderful, wonderful. And you make so many good points, Setsuko. I was just thinking as you were talking about some of the things that, so if we look at the US law, the 2015, which was the first national law in this modern era that really looked at space resources, it did exactly what you said. It galvanized the international community to say, hey, this is an issue we really need to discuss at a multilateral level as well. So having that national law put in actually gave rise to the discussion, and now the discussions are being developed through working groups and whatever, and we shall see. Nobody can prejudge. But the interesting point in that legislation, and you mentioned it for the Japanese legislation, is they say, yes, national law says this, subject to international law and obligations. And so there's always this understanding of an interplay. So Peter, and maybe this will be our last question, and Torsten will go to the audience. Where should we be getting the ideas for governing space? Should we be getting it, and I suspect you will say yes, should we be getting it from all layers of society, civil society, unilateral actions, national law, minilateralism, and a whole range of things? is it appropriate for all of those ideas to come to the international multilateral level? And then how do we filter that? Because as you've said, different countries have different perspectives. And of course, Antonino makes the excellent point in the chat. Thanks, Antonino. Of course, the young generation, future generations are so crucial. So Peter, how do we get this mulligatawny soup to be actually put together in a way where all of those voices are heard, given the different vested interests between different countries?
Well, there is, of course, not a perfect answer to this. And I know that I sometimes perhaps sound a little bit like a dinosaur when I'm bandying around rule of law, etc., etc. But in my defense, I have to say that I am also a long-standing advocate of the space community rediscovering how to make law. And you can argue that what we are seeing in space resources is exactly that. I am, as you will have noticed, on a somewhat different page than my distinguished colleague here, Setsuko. But we should perhaps look really at what are the classical mechanisms for changing the law, because it is true that in a fantastically dynamic environment like space right now, even a treaty 60 years old, which relatively speaking is not so old, but for our community is old. How do we evolve it? How do we make sure that it fits new circumstances, etc., etc.? And without making a lecture on normative systems in international law, we should perhaps remember what the acknowledged tools are, and Setsuko addressed it to some extent. So first of all, it is natural in law that interpretations evolve. We know that. So what was an accepted interpretation 50 years ago might not be an accepted interpretation today. But this is within the constraints of the rule system that is defined. So it is not unbounded. And then, of course, you can change law by making new law, by making treaties and agreements, etc., etc., which is a highly respectable way of changing the law. And of course, you can change it by new customary rules, and according to me, also new general principles of law. And when these customary rules arise because they limit freedom, if you wish, then there is no problem. But of course, customary rules can also arise against the existing law, as we Latin-orientated lawyers are always saying, contra legem. So you have contra legem customary rules, and this is perhaps what we are experiencing now. This is perhaps also what Setsuko was addressing a little bit, that without beating the dead horse of space resources, perhaps what we are seeing is that a customary rule is gradually being built against the existing law, because I think if you need evidence of what the OST is, what the Outer Space Treaty is saying, then you look at why do we have the Moon Agreement. It is because there was a prohibitory norm, and now it becomes permissive through the agreement. But this might also be achieved through a customary rule that arises against the law. This is, of course, the ugliest way of creating new law, because it ultimately favors, if you wish, the most dynamic actor, which you can argue is fair or not fair, but it leaves aside the community perspective. And I think it is very sad that the space community, like a lot of the rest of the international community, is so reluctant about new treaty making. If we don't like the Moon Agreement, fine. I think it's actually good, and it needs further fleshing out. But if we don't like it, then let's sit together and create new norms that will satisfy the needs of community now. But let's not make the illusion that there is no existing framework, that there is no existing prohibitions. This we have to accept, and we can then look at how do we change it if it is not satisfactory. And I think it is absolutely important for us not to have ultimately just might is right, that we get back to proper lawmaking and acceptance that ultimately the rule of law helps us all.
Yeah, thanks, Peter. I mean, I'm a bit more optimistic than you when it comes to space, at least, but I agree with you. These are strange geopolitical times. We're not going to have treaties made in any, multilateral treaties on any big issue. And yet we're beginning to see consensus, some, let's say, big issues in space at COPOS, which I think shows a willingness to find a way, a willingness to begin to recognize that, as you put it before, if we screw it up for one, we screw it up for all. So we've just got to keep on having those discussions. I'm also glad you said that the Outer Space Treaty is not that old, because I'm a Sputnik baby and I'm older than the Outer Space Treaty. So thank you for that. Torsten, I know we're, of course, always running late, but do we have time for a couple of questions from the audience?
Absolutely. Yeah, and I just want to say kudos to Peter. I mean, I get goosebumps to hear ugly and space law in one sentence. So it's no, we have really a number of questions here which are really we can't answer, but I would like to send you, Stephen, this over then later on to maybe offer a written answer. And I mean, on the national or space law side, I had on Tuesday, and we put it online yesterday, the opportunity to speak to your successor at SP, Peter, with Jean-Jacques Tortora about European space law and what is at stake in Europe, I mean, in the current situation. And that was very, very interesting, because on the national side, we are so diverse, and we are proud of it, that to find a consensus even on the European level, and I'm not talking about the UN level here, will be a challenge. I mean, Denmark, Luxembourg space law look very different to the non-existing German space law, and we want to be a player in the field. And I can't say that again and again that Germany doesn't have a space law. And I think, for me personally, and I'm speaking as Torsten here, as a German citizen, it's a shame. So, to the questions. So, one, I hope easy one here is from Harini, I think from Bangalore, if I read that correctly. She asked about a little bit technical. Would it be okay to see the Moon Agreement and the Artemis Accord in comparison to each other? So, how would you put them? I mean, that I think goes along well with the topic you touched on.
I can speak on this, but perhaps Setsuko or Peter, would you like to say something also about Artemis and the Moon Agreement?
Oh, no, please do.
Yeah, I can talk to this. I think this is a very relevant question, because in a sense, of course, the Artemis Agreement is intended to be, if you wish, an alternative to the Moon Agreement. So you can argue that in terms of lawmaking, there is something traditional in this, something similar actually to a treaty I like a lot, which is the Nuclear Ban Treaty. You know, it starts in a smaller forum, and then there is a hope that it expands. This is also the idea behind the Artemis Agreement, that gradually it can gain general acceptance, I believe. The problem from my perspective, but probably not for Setsuko's perspective, is that the Artemis Agreement, although it says within the boundaries of international law, the whole intent is to change international law from something which is restrictive to something which gives freedom. So it is ultimately an attempt to change the law contra legem.
Interesting. Setsuko, did you want to say anything on this? No.
Well, so only one word. It's not, well, equity contra legem. I would rather say equity, praeter legem. And Artemis Accord is just a political statement. It's not a treaty. So, well, from that point, well, there are so, well, many roads to go. So
Yeah.
I'm more optimistic about the well, resilience of space law.
Thank you. It's
interesting. You're
interesting.
setting facts. That's the situation.
And I'm speaking to you from the only country in the world that is both a party to the Moon Agreement and a signatory to the Artemis Accords, right? And there's been lots of scholarship. I mean, international academics, they love writing articles saying sensationalist stuff. Oh, this is an absolute outrage and a breach, and Australia is in breach of everything. Okay, I think even having Peter and Setsuko having slightly different perspectives on it shows that, as we said before, things are a question of interpretation. So the Australian government, and I'm not a spokesperson for the Australian government, I'm not involved in this, the Australian government clearly has said, by becoming a signatory of the Artemis Accords, they in no way feel they are compromising their obligations and rights under the Moon Agreement. Now, others may disagree. This is one of those areas where interpretation is everything. But it is important. You know, the Artemis Accords, like many other initiatives, is another input, if you like, to what will become broader multilateral discussions. So from the Australian government's perspective, and in a sense, they are the only ones that matter at the moment because they are the only ones who are involved in both. From their perspective, they can sit alongside each other without any problems. Others may disagree, but as Peter and Setsuko said, in the end, you know, there are some flexibilities of interpretation, and we shall see. But I don't think we need to jump to conclusions and say this is a disaster or not. I think we need to be patient and just see how the discussions evolve down the track amongst all of the member states of COPWAS. So I'm on your side, Setsuko, on this one. I'm more optimistic, but Peter, your concerns are very valid. I get that. Torsten, you're in charge. Do we have time for one more question? Or not?
Yeah, I think we just go for another one. So Mark's question, I mean, looks very short as a question, but obviously that's a dangerous with the short things that they're becoming then very, very big in the answer. So can national space law control the obligations of space law?
Peter.
Well, can control? No, I mean, you know, I'm a monist, and I don't want to explain to you too much, but I see the legal system as being one. So international law, national law, they're all part of one construct. And the way we understand it is, of course, that international law ultimately makes instructions to domestic law that must be implemented. And it is not an excuse to have a national law that is contrary to international law. It is not an excuse for the country not to follow its international obligations. So in this respect, you can say there is a flow down, but it is also true that there is a flow up. So in terms of creating customary law, in terms of creating binding interpretations of what actually the international law treaties mean, national legislation is also very important. So you can argue what practice is and whether a law is practice or whether it has to be followed by actual action in outer law, outer space, etc., etc. But ultimately, the reality is that there is a bidirectional dialogue between international law and national law, and that is good. Don't get me wrong. This is what we need, because we need engagement on both sides. So ultimately, national law can, as I said before, also lead to a change of international law against what was there before. But it can also be uncontroversial in terms of explaining to us how countries in practice will interpret their obligations under international law. But it is important to understand, from my perspective, that it's all part of one construct.
Thank you, Peter. Yeah, I agree with this two-way street. Setsuko, your thoughts, your last thoughts on this, or anything that we've discussed. Yeah.
Well, this is too philosophical question, and philosophical. Well, it's yes, as long as it is about the jurisdiction to prescriptive, but national law can control only the event happened in its own territory, and well, it's nationals, as long as that law provides so. So for enforcement jurisdiction wise, well, no, and jurisdiction to prescribe, yes, but it's not done. Well, concrete answer. Sorry.
Thank you. No, thank you. So you're right. It is a two-way street. Yeah, under space law, national law is an implementation, so it's informed by the international system. But as Peter says and Setsuko says, there is an upward flow of ideas, of perhaps creation of customary law, and that is a good thing. It makes for the richness of space law and the multifaceted nature of space law. So I think we're out of time. The production team's getting nervous, I'm told. Torsten, I'll hand it to you. But before I do that, Peter and Setsuko, it's just been an honor and a privilege to have you. Thank you so much. Setsuko, thank you for hosting us in Tokyo. Next year, let us all meet actually in person at the cafe. Peter, thank you again for your incredible insights. You are two dear friends, but I learn from both of you every day. So thank you for joining us. Torsten, I'll hand it back to you.
Am I just allowed to make one comment?
No, but yes, of course you are.
Because I wanted nothing to do with space law, but I wanted to give a compliment to Torsten, which also touches upon our topic. Because there's so much going on in space right now. And I would have said 20 years ago that something like what Torsten is doing here would have been inconceivable. And it is so fantastic to see the richness of what his organization is offering here. So with your breakfast and so on, but all the information that you can find through Torsten's various outlets, it is amazing, and it shows also how healthy actually the space community is. So thank you very much for that, Torsten.
Thank you. So I'm not that often speechless, but I'm almost have been. Thank you very much. And thank you for this fantastic panel. I mean, we get so much nice feedback here in the chat, as well from Divya, Maria, Jan. Big promise to Mark, Jan, and Harini. Your questions will be taken care of by Steven, and we will send an answer, or we offer an answer in a few days. Together we see video. So yes, our production team brings it up. So we have for you our next Space Café Space Law Breakfast by Steven, and he didn't mention it, but I will leave it to you, to Steven, to mention who your guests are. So Mark saves the date, 25th of November. our same time here in Europe. At least Australia will move 2 hours away, so it will be then 7:30 p.m. in Australia as we all go to wintertime or summertime or wherever we are going. Steven,
yes, it'll be a very late breakfast. Yeah, a very late breakfast. But please, if you enjoyed today, and I mean, who could not enjoy listening to Peter and Torsten and Setsuko? But if you enjoyed today, come next time on the 25th. We've got Joanne Wheeler, who's an incredible commercial lawyer in the UK, and Michael Davis, who's an inspiration in Australia, and runs a foundation that's helping to promote activities in space and education. So Joanne Wheeler, Michael Davis, they'll be joining Torsten and I, probably from London, I think, Torsten, or maybe from Adelaide. I'm not sure yet. We'll decide. On the 25th, the details are on there. Please save the date and come along. While I've got the floor, thank you again, Peter. Thank you again, Setsuko. It's just a delight. And your comments are just so extraordinary. Torsten, thank you again for I can only endorse what Peter says about SpaceWatch.Global platform. And, I'm a part of it now, but you have done an incredible thing to bring to the conscience of people all of the perspectives of space. And in our small way, these cafes, I hope, help. So thank you, Torsten, and the production team, Frank and Chiara. And I'll pass it back to you, Torsten.
Thank you. Thank you very much. Thank you very much for these kind words, and it's a great pleasure to serve the market, the sector, and we couldn't be there without your fantastic voices from all of you. And I mean, we just provide the platform at the end for all of you. So thanks for jumping on that. So please, audience, stay with us for 2 more minutes. So we have some nice events are lined up. Today, our very own Chiara Monta will be guest at the Astro Agency's Space Bar in Edinburgh, our European evening, I think, or 8 p.m. today. Then tomorrow, don't miss that. We have our Space Café Canada by the fantastic Jessica West, and she will be talking with Samantha Lawler about the night sky, the bright night sky. So a topic we didn't address today, but it goes along the lines of space sustainability, what we are all looking for. So that will happen tomorrow, and it's unfavorable for Australia and Japan. It will be 6 p.m. CEST, 12 p.m. Eastern Daytime in the US. So because she will do that from Waterloo in Canada. And then next week, I have the great pleasure, together with Chiara, to be in Geneva, so real travel. So at the UNIDIR Space Security Conference this year. So, and we will talk on Tuesday with no one less than the director of UNIDIR, the new one, Robin Geis. So we will try to make it live from the floor. We work on that, how that will technically be possible, but stay with us. You will hear Robin and me talking. And a week later, we have Mike Simmons talking about the overview effect, also something what is very, very important for all of us. All these events are online on Eventbrite. And as always, we would like to hear your feedback. So please check in with us on Twitter, on Facebook or LinkedIn. Don't forget to sign up to our daily or bi-weekly newsletters. And again, if you like to treat yourself with something special, become a Space Watcher today. Become part of the family. And Steven showed that we have these T-shirts in a number of colors, and they are fitting very well. So please take your credit card, visit our fan shop at shop.spacewatch.global. And I know I repeat myself, and when it comes to money, it's always not a pleasant task, but hey, we have to fill the fridge somehow and keep the lights on. Thank you all very much for your interest today. Thank you, Setsuko. Thank you, Peter, for your inspiring
Thank you very much.
And being our guest in this session here. And Steven, that's it. I hope you have been happy with this program. today.
Oh, it just gets better and better.
I see it in your eyes.
Yeah, I'm just delighted and thrilled and can't wait for the next one, but still will enjoy rethinking about all the incredible things we've discussed today. So, and thank you to the audience for your questions. We'll look at them. It's just so great that people hang around and listen to these inspiring talks. So yeah, very happy indeed.
Thanks again to the entire team behind the scenes, Frank and his team, for doing their great job. And I hope you all will stay safe and stay healthy. In the meantime, don't forget, become a space watcher. Thank you very much. Bye-bye.
Bye.
Bye, everybody.
Thank you very much.